right. You may proceed.
May it please the court, Mario Garcia for the appellant. I draw International Drive Flea Market. I do want to reserve, I think, 5 minutes for rebuttal.
Okay.
So thank you, Your Honor. The facts in this case, the record clearly shows what the facts are, even if the judge's ruling does not. The key question in this case is whether Orlacross had notice of an extension to a lease. Now, the judge found that there was no such notice, either by duty of inquiry or actual notice. The facts are much different. In fact, in his own...
Actual notice, there was disputed testimony, right? So we have to accept the trial court's determination there wasn't actual notice.
I don't think so, because there really wasn't even competent evidence that there was an actual notice. The actual evidence shows it, and I'll show you where it says it. Number one, both Mr. Rosenberg and the attorney, Mr. Brown, testified. First, that each of them received a tenant estoppel certificate. Paragraph 2 of the tenant estoppel certificate clearly sets forth the terms of the extension. Clearly, it says the initial lease term will be extended to 2016. Every term thereafter, rent will be fixed at $25,000. So, even before the December 30, 2010 closing on the note and mortgage, Orlacross had actual knowledge. Mr. Rosenberg, in his testimony, again, in the transcript, page 74 and page 75, lines 25, Rosenberg conceded that he assumed there were amendments in some legal documents that extended the lease, but had been informed that these documents didn't have any legal power. So the reality is, they had noticed that something was up. The tenant estoppel told them specifically what the Third Amendment final version said, and they chose to ignore it. Mr. Brown said, well, you know, I don't pay attention to estoppel certificates because they can't trump the lease terms. He obviously didn't pay attention to his duty of performing due diligence. So no, I think the judge got that wrong. You know, maybe reasons, there's some odd things that happened in this case. It took 9 months for a ruling. On the eve that Judge Kamansky was resigning, he signed this final judgment.
Did your client meet with Orlacross, or did Orlacross get all of its information from the landlord?
From who? Well, my client did meet with Orlacross. Okay. They had a pretty long meeting.
And what did your client provide with regard to the status of the lease?
At that point, Your Honor, there was talk about Mr. Rosenberg having all 3 of the amendments, and my client said he assumed he had the final version because the first version had been discarded and had been superseded by the final version. He did tell Mr. Rosenberg that he did have a long lease. Based on Mr. Rosenberg's testimony, he believed that even under the amendments, the lease would end on December 2011, which was less than a year from the date that they purchased the note and mortgage and then subsequently the center. So in other words, he again was apprised, but Mr. Rosenberg's testimony there is again suspicious. He says he didn't believe him. He says he wasn't going to believe him. He thought these amendments didn't have any legal power, so he decided not to inquire further, not to demand that Mr. Nandu of the flea market state why he felt he had a long lease. And he basically left it, he even said in his testimony that he left his attorneys handle that. And his attorney miserably failed. He's a brethren, and I understand the situation. He wasn't an expert. My opponent may argue that he has all this experience, but there was only testimony that he was an attorney since 1985. That was all that was told about his qualifications. He testified that he received the Third Amendment version 1 only. But Third Amendment version 1 mentions a lease extension, tells him that the parties will execute an extension to the lease.
Would a extension to the lease that they will execute have to be approved by the mortgage holder?
No. The actual language that was used in the lease, paragraph 15, is that the mortgage holder has the right to accept or reject the lease. So if
they agreed they will enter into a lease extension, that doesn't mean that there will necessarily be a valid lease extension because the possibility exists that the mortgage holder will reject it. Correct?
Well, I would say no. I don't think the mortgage holder, under the provisions that were in the lease, have the right, other than to foreclose. I mean, when you say prior approval by the landlord, or prior approval, in this case by the mortgagee, I could understand the argument that until that's been pre-approved, you may not have a valid extension. However, that's not the language used in this lease. It was the mortgagee had the right to accept or reject, and that language...
If it's meaningless, basically, then what's the point of even having that provision in there?
Oh, it's not a meaningless provision. It's a provision that was couched inside a paragraph called subordination. So it's a provision to basically ensure the bank that it doesn't have to, under any circumstances, honor any leases that have been extended without their approval, without their acceptance. So it gave the mortgagee the right to foreclose the minute they found there was an unacceptable or rejectable lease. But it doesn't...
You're saying that that would be a default in the mortgage as opposed to an approval provision?
That would be a default under the mortgage. I think that if indeed the bank had chosen to, and mind you, there were amendments all along since 2007, 2008, and the final 2010.
But the bank couldn't just reject the lease and say you're not allowed to do that extension, they would have to foreclose? Is that your position?
Under the case law, Your Honor, under the case law of Morris versus Osteen, that has to be my position, because there's no privity of contract between... The bank does not have a right to evict a tenant. That's clear in the case law. The bank's rights are strictly to enforce its mortgage.
Well, the bank has a right to not approve a lease extension under the terms of its agreement with the landlord, right?
To accept a lease extension. I think the language is very important, because normally you see this approval language, and normally you see prior approval language. Here you have accept and reject in the subordination paragraph of the lease.
They have a right under the contract to reject a lease extension.
Correct.
If their only remedy is to foreclose, if they're asked to approve, whether they reject the lease extension, isn't their option to simply reject the lease extension and say to the landlord, you can't enter into that contract because of your contract with us?
Well, how would they enforce it? In other words, they couldn't enforce it against the tenant. They would have to enforce it only against the contracting party, in this case, the mortgagor. Now, it's up to if the mortgagor chooses to give a lease to a tenant, it's his obligation to his bank and his lender whether that was appropriate or not. I would submit, though, that in this particular case, the bank, the mercantile bank, whether, they had two amendments that had already been put in place that arguably, if you believe the Orlacross, had not been approved by Mercantile Bank. There's no evidence whether they had approved these amendments or not. And once Orlacross is deemed to have known that there was this extension, there was a Third Amendment version 2, or at least knew about the actual rights that the flea market had, and by the estoppel certificate they did. Once they knew that, then they took the property subject to this Third Amendment final version. Then it becomes their burden to try to argue against its own validity. Now, when they argue again about the validity of paragraph 15 because of the approval, there's two problems they have. Understanding the bank's only rights, according to the case law, is to foreclose. They don't have a right of immediate possession. They don't have a right to throw out the tenant. They have a right to pressure their mortgagor into throwing the tenant out or being foreclosed. That was never done in the several years here. Now, I also think it's a red herring, because Orlacross never sued to foreclose the mortgage, and it could have. It had the opportunity to do it and chose not to do it. So when they did sue, they sued only as a landlord. And when you put yourself in that landlord's position, the very landlord that signed the Third Amendment final version 1 and version 1 and final version 2, that very same landlord, when you put yourself in those shoes, he doesn't have the right at this point, after several years of this amendment, to argue against the validity. So that's why I think that's a non-issue, the approval issue. Because at the time that this action was brought, and many months before, I would argue that the minute that Orlacross purchased the property from the mortgagor, the interest of the mortgage and the title merged, and that was in February of 2011. This action was brought at the end of 2011 because Orlacross believed that the Third Amendment version 1 was valid. Otherwise, they wouldn't have waited till December to go ahead and try to evict him.
They believe that Orlacross only had the first version of the Third Amendment.
Right, but according to that first version, they were going to get reduced rent for $25,000 until the end of December 2011. And so, in that same agreement, wasn't, you know, if version 2 wasn't approved, version 1 wasn't approved. And they had version 1. So they knew about the approval issue. They even knew about the statute of frauds issue. They knew because they had a lawyer review it, and any lawyer would have reviewed it and said, oh, there's an approval necessary. Let me contact Mercantile Bank and see if it was approved. Not done. Oh, it looks a little funny with the statute of frauds. Let me contact the seller and see what happened here. Not done. In this case, Orlacross not only knew about this, but then chose a route to take where it ignored its right to foreclose the flea market's interest, okay? Instead, they dismissed the foreclosure, they filed the eviction, and here we are. And they filed it under a summary procedure. Now, this isn't a summary proceeding case, and it didn't go on like a summary procedure because it took a couple of years for trial. Why did they file it? Because they're trying to, I think Orlacross was trying to limit our defenses and to try to argue about the burden of proof. But ultimately here, they knew about that final Third Amendment, or at least knew about the terms. So therefore, they took subject to that. And at that point, they had the requirement to do some due diligence. Was it approved? And here's the interesting fact. Even Don Brown admitted in his testimony, after he didn't call up, he emailed Zinzao, the opposing counsel, the seller's counsel, to ask about this extension reference in the third. Never mind, he had a tenant estoppel also. He didn't reference that. So he emailed him and he said, what about this extension? Was it ever signed? I don't know, came the answer. And that wasn't enough. It was an I don't know, and you have no right to ask that because you haven't obtained the financing yet. So here you have a very equivocal answer, and even a little push about not wanting to give you the answer. That satisfied Mr. Initially, he said that the answer didn't satisfy him, but what did satisfy him was the First, Second, Third Amendment, the lease, and then there was a document that was signed by both the flea market and the original landlord, which said that all the amendments were valid, and all the amendments had been signed properly. And in his testimony, Mr. Brown said he assumed everything was proper. It wasn't only after that the closings were held that suddenly, 2 or 3 months before the lawsuit was filed, over a year and a half, or almost 2 years after this Third Amendment was signed, either the first or the second, they were signed the first day, only then did Mr. Brown get involved and say, hey, did you guys get this approval? I don't see the approval. And then on the eve of trial is when we get a memorandum for the first time referencing the statute of frauds. Now, all these issues were in Orlacross's hands when it was evaluating the noted mortgage. It had the tenant estoppel, it had the lease that said paragraph 15, accept or reject, it had the First Third Amendment, and that First Third Amendment, arguably, admittedly, is identical to the second, except in font, and paragraph 2 was significantly changed. But the Third Amendment version 1 and the Third Amendment final version dovetail each other because the second paragraph says, in version 1, the parties will enter into an extension of the lease, and the landlord will remove its right to evict my guy if he finds a better tenant. That's exactly what occurred in the Third Amendment version 2. So it dovetails it, it was in their possession, it was in their sights. I don't really see a big argument regarding the statute of frauds. I think we'd be right.
Let me ask you this. You have 3 points in your brief. Do you agree that you have to succeed on all 3 of them, and if you don't succeed on any of them, you lose?
They had notice.
Statute of frauds, prior approval. They can...
I do, except I would argue that if they actually knew, if they knew about the terms of the Third Amendment version 2, never mind they didn't have a copy of it, but they knew because they had the tenant estoppel certificate. They knew because they had, Mr. Rosenberg admitted he knew. If they actually knew that, and they did nothing about it, and they stepped into the shoes, as they did when they filed, of the original landlord, then the fourth argument might be, in spite of the fact that second and third prongs aren't clear winners, there's a bit of a waiver argument. Now, I understand we get into that area of factual and the judge's discretion and all this, but we have some pretty weird stuff here. We have a judgment that says, oh, there was not even implied notice.
Presented a .4 waiver, though. That's not one of your issues on appeal, right?
Well, it's estoppel is how I presented it. In other words, on the statute of frauds, and also...
Yeah, but answer is quite, waiver is not an issue in this case, is it?
Well, I would call it estoppel.
Well, the estoppel and waiver are different, aren't they?
Somewhat.
Waiver's not an issue in this case, is it?
Well, I argued it in the lower court.
So, in other words, if you lose on any one of the three issues that are issues in this case, and that's it, they can prevail on one, and that's it for you.
Well, again, I hesitate to say yes, but I would say yes with the proviso that we have the estoppel argument, that if they knew and they sat back, they also stepped into the shoes of the original landlord. That means that several years have gone by.
They claim they did not know about the second version of the Third Amendment. They claim they don't, and that's the issue that the trial court resolved. And
but how could they say that, Your Honor? Your Honor, how can they actually say?
How could they know there's a lease, an amendment, and they've got this Third Amendment. They've asked for the information regarding the extensions. They're given this first version of the Third Amendment to the lease. Are they just supposed to know that there's a second version of a Third Amendment to the lease?
But that's not what happened. Let's be clear. They received the First Amendment, okay? And Mr. Zinzal saw the First Amendment and referenced lease extension. Mr. Brown. Mr. Brown then contacted by email, and he testified no other contact. There was no other contact but this email and the response. No phone calls to the flea market, no phone calls to the tenant, nothing. He went ahead and he reviewed and sent an email saying, I see a reference to an extension here. Was there one signed? The answer was, I don't know. The answer wasn't no. And that's one of the cases. In the Bowden case, it was the Kreutz case, the attorney was smart enough to get a tenant estoppel certificate. And in the tenant estoppel certificate, the tenant didn't get a tenant estoppel certificate in that case, and the judge ruled it should have. Here, he got a tenant estoppel certificate. He did that properly, but then he ignored it. Then he ignored the tenant estoppel certificate. Paragraph 2 of the tenant estoppel certificate, basically, tenant's rent and term obligations are as follows. The expiration date is extended till October 31, 2016, as set forth in the lease as amended. The total monthly rent during the entire term, as well as the extensions of the lease term, as defined by paragraph 2.1 of the lease, shall continue to be a fixed amount of $25,000, which will include sales tax.
Wrap it up, because you've only got about a minute and 30 seconds left, so you want to reserve the rest of that time?
Okay. So I would say that the trial court erred in ruling that they did not have actual notice, but even if they didn't err there, he erred in ruling that there wasn't implied actual notice. There was enough information here for Mr. Brown and Mr. Rosenberg to approach the tenant specifically.
A couple minutes for rebuttal, but you're starting to go over
Thank you.
time. Okay.
Good morning. May it please the court. I'm Patrick McGee. I represent the Appellate Orlacross. The flea market's challenge in this appeal is rather comprehensive and daunting. As Mr. Garcia quasi-conceded, he needs to prevail on all of the issues on the appeal, or else he loses. He gets no relief. The flea market sought to avoid eviction below by asserting modifications of the lease. However, the trial court found that the flea market failed to carry its burden of proving that it's entitled to pay rent in an amount less than the amount stated in the lease itself. The final judgment below laid out multiple independent reasons as to why the flea market lost its case. And the epicenter of this case plainly is the Third Amendment version 2. And to clear up some terminology in this case, Mr. Garcia talks about an extension of the lease. There is no extension of the lease. There's not one in evidence. There's not one that's been discussed as being an actual document. What occurred in this case, in the Third Amendment version 2, which Orlacross did not have, and the trial court so found, is that the amount of rent was purportedly changed in that document from the lease amount, which at the time of the eviction was in excess of $62,000 a year plus tax, to $25,000 per year, including tax, throughout the initial lease term, which ended in October 2011, and throughout all the extensions, 3 5-year extensions. So that would have taken the term out to 2026. What this document purports to say is not that we're extending the lease, but that to the extent there's rent owed in the initial lease term or any of the 3 option periods, it's going to be $25,000 per month, including tax, rather than the $60-some-odd thousand set forth and escalating rent set forth in the lease itself.
Which is a significant difference between version 1 and version 2.
It's a remarkably significant difference. If you compare just the pass-throughs, the landlord's expenses of real estate and taxes and maintenance, that's in excess of $15,000 per month estimated in the lease itself. And this is a 46,000 square foot space on International Drive, the heart of the tourist district in Orlando, that the flea market wanted the right to occupy on those rental terms until 2026. The suggestion by Mr. Garcia that the evidence at trial was that Orlacross knew of this Third Amendment version 2, it's just not in the record. In fact, the trial court in the final judgment expressly said that the weight and credibility of the Third Amendment version 2 were significantly undermined by, among other things, the absence of direct evidence that either Orlacross, the prior landlord, or anyone else other than the flea market had seen this Third Amendment version 2 before it was attached to flea market's answer, and that was in the eviction action. So yes, there was a Third Amendment version 1 that Orlacross and its attorney, who was doing due diligence, did have in his possession. He also had the estoppel, which was the document that was signed by the flea market and directed to Orlacross itself, and it said in there that Orlacross may rely on this certificate as conclusive evidence of the matters stated herein. It listed the documents that the flea market occupied the premises under. The lease, with the date of the lease, November 2006. The First Amendment, dated April 6, 2006. The Second Amendment, dated January 1, 2008. And Third Amendment, dated January 1, 2010. Didn't mention 2 Third Amendments, although Mr. Nandu, the flea market's representative, testified at trial that he signed 2 versions of those documents. And but he mentions only 1 here. And then the estoppel to Orlacross says, tenant has not entered into any agreement that provides for any other material modification of the lease. So that representation was made to Orlacross. That representation was in the hands of attorney Don Brown, who handled the closing and the due diligence for Orlacross. And incidentally, regarding Mr. Brown's qualifications, he was not just an attorney who had been a member of the Florida Bar since 1981. The final judgment stated on paragraph 9, and he is experienced in closing real estate transactions. Mr. Brown did testify as to several issues of what was reasonable and customary for an attorney in this situation to do. In fact, the the final judgment itself on what the judge called these duty of inquiry defenses, stated specifically that it would be unreasonable to require Mr. Brown, under the circumstances, to perceive that a complete set of fully executed lease documents that he had might have alternate versions, and that he should inquire of the flea market regarding that possibility. The judge also found on these defenses, and these are factual findings by the court based upon the evidence, that the flea market offered no evidence to rebut Mr. Brown's testimony that he did what was reasonable, customary, or prudent for a real estate attorney under the facts of this case. The flea market failed to prove that the steps taken by Orlacross's attorney, Don Brown, were unreasonable regarding due diligence. The circumstances and the evidence did not prove that the constructive or implied knowledge should be imposed on Orlacross. The flea market did not prove that Orlacross knew or should have known that there were alternate versions of a January 1, 2010 document titled Third Amendment to the Lease. The evidence at trial did not prove that Mr. Brown should have taken any further steps on behalf of Orlacross. The flea market failed to prove that Orlacross had a further duty to investigate under these circumstances. So on that basis alone, that should end the inquiry here. The court made findings of fact. There is substantial competent evidence in the record to support those findings of fact. Orlacross is not an assignee here of the lease. Orlacross is a subsequent purchaser of the property that takes, subject to those matters, those interests of the tenant that the landlord either had actual knowledge of, or when there is knowledge imputed to the landlord under the circumstances of this case. And what the trial judge did is put a hammer on that issue as far as the flea market's arguments. It said, under all of these circumstances, I find that there's no reason to say that Orlacross should have known of these items, and Orlacross definitely did not know of the interests asserted by the flea market in the Third Amendment version 2, and first asserted by the flea market in its answer to the eviction complaint itself.
One other thing I note that the trial court did, and I think footnote 8 was note, when we get to the discussion about imputed knowledge, that the flea market could have recorded a copy of that second version in public records and did not, and had they, then certainly your client would have been imputed with the knowledge of that.
It would have constructive knowledge, tantamount to actual knowledge of that document. The flea market responds that there were restrictions on recording the lease itself, but the lease also allowed for the recording of a memorandum of the lease in the public records. It says nothing about the amendments, and there's no restriction on the amendments. The other thing that the flea market could have done was simply provide a complete set of documents to Orlacross. The flea market could have mentioned a complete set of documents in its estoppel to Orlacross, not just Third Amendment, but both Third Amendments that it signs. And as the trial court points out in its final judgment, Mr. Nandu, on behalf of the flea market, admitted that he signed both documents. What his further testimony was, well, I discarded mine, it superseded it. That doesn't change the fact that both documents existed. There's no evidence from the original landlord that it discarded the Third Amendment version 1. It's a document that did exist, purportedly, and under those circumstances, that affected the trial court's decision as to what was reasonable for Orlacross to do under these circumstances. So the only knowledge that would be imputed to Orlacross regarding the interests of the flea market, and the only interests that Orlacross would take title to, subject to, respecting the flea market, would be those interests that Orlacross had actual knowledge of, or that is reasonably imputed to Orlacross. And that issue is set forth in great detail and resolved by the trial court in the final judgment. I'd like to briefly touch on a couple of other alternate points. The statute of frauds issue, this is two parts. The first part is the interpretation of the statute itself. The second part is the argument by flea market that Orlacross should be stopped to raise the issue of the statute of frauds. The Third Amendment both version 1 and version 2, state on their face what the witnesses, subscribing witnesses, were witnesses to. Mr. Jean, nobody is really sure what his last name is for the landlord, says, I am the witness as to the lessor. Mrs. Nandu states in there, I am the witness for the lessee. What the attempt by the flea market at trial was to supplement what was in the four corners of the document and say, and by the way, that Mr. Jean, he also witnessed the tenant's signature, and I, Mrs. Nandu, also witnessed the landlord's signature, and the court said that won't do. Then the flea market argues that the statute should be interpreted. There were two subscribing witnesses here, but that's not enough. The trial court said the statute requires two subscribing witnesses per party that is creating the interest, and there was only one per party in this case, and as the trial court said, it's two witnesses per party, not two witnesses per document for an unlimited number of parties. And then with respect to the approval process required under the lease, Mr. Nandu testified, and this is what the trial court said itself. Mr. Nandu conceded at trial that he knew the lease required the lender's approval for a lease amendment. So this isn't a question of making it voidable. It's just, is it enforceable? Is there the approval, was approval obtained for any of these lease amendments? Of course, the only one that's important is the third lease amendment, and it was not. So on the basis of all of those issues, three of those issues, any one of which sinks the flea market's ship in this appeal, we would respectfully ask the court to affirm Judge Kamansky's final judgment.
Thank you.
If there are any questions, thank you.
Thank you.
First, Your Honor, the amendments of $25,000 a month had been in place basically since the existence of the lease. It was signed in 2006. Within months of that, the tenant and the landlord agreed to $25,000 a month.
Let me ask you this. With regard to the timing in which the second version of the Third Amendment to the lease was presented to the purchaser, to Orla, I can't remember the name. It's my understanding that that second version to the Third Amendment wasn't presented till the time the answer was filed in this lawsuit.
That's correct, and the reason was that nobody asked my client. The duty to inquire is on the purchaser.
But at some point in time, Orlacross was honoring, up to the end of this lease term, was honoring the $25,000 a month. And then when that lease ended and the new term was beginning, their argument was, hey, now you don't owe us $25,000 anymore. Now you owe us what's under the original lease, and they go back to that. So what would seem logical to me is at that point, someone would say, hey, wait a minute, no, I've got this Third Amendment, and this is specifically what it says, but it all of a sudden shows up at the time that the answer's filed.
Well,
Isn't that strange?
I don't think it's strange at all,
You
because...
don't think the trial court could find that was odd?
I'll tell you why I don't. Let's look at the testimony. This was entered into on January the 1st. My client and his wife testified that they met at the flea market with the landlord and Mr. Gene Holian. His name appears, you can read it. And in the morning, they signed version 1. And version 1 clearly states that they intend to sign an extension, and that if that's signed, the landlord will remove his right or ability to get my guy kicked out. That was signed in the morning. Within a couple of hours of that, they signed the final version. At that point, and it's important to note that the original version of the final Third Amendment is the one that was submitted as evidence into the court. Notwithstanding Orlacross's contention in his brief, I checked the record over and over again, the original Third Amendment final version was what was submitted to the court. My client testified, once he signed the Third Amendment, he didn't think there was a reason to keep the first version that had been signed a couple hours earlier. That's why he too became came to think, especially after he gave his tenant estoppel, that they had that information. When he met with Mr. Rosenberg, he told Mr. Rosenberg, oh, I have a long lease. Mr. Rosenberg didn't ask anything further. That's really, when they cry and they say, we didn't have this, they tried so hard not to get it. They didn't ask the tenant and say, where do you get this tenant, estoppel stuff? They didn't go to Zinzao and say, what do you mean you don't know?
You need to wrap it up because you've...
We need to know this. The $250,000 was on both versions of Final Third, 1 and 2. That was the termination fee. That makes it very reasonable. If they don't want to pay take the $25,000 a month, they can go ahead and take the $250,000. And Mr. Rosenberg in his testimony said he was prepared to pay it.
Time's exhausted. Thank you. Thank you both. Well argued on both sides. All right.